So Paul, could you get us started and talk about the arbitration cases, how they're similar, how they're different?
I'd be delighted to, Glenn. It's great to be with you and your audience and with Michael. Really appreciate the opportunity to talk about the arbitration trilogy that will be all argued in the March argument sitting. I think 3 arbitration cases in one sitting of the court, just in a 2-week sitting, has got to be some kind of record. I'm privileged to be involved directly in 2 of them, but I'll start by talking about the case that I'm not involved in. I think the foundation has filed in all 3 of these cases, though. So I think these are obviously important cases to everyone who is a believer in the efficiencies of arbitration. So the case that I'm not involved in is a case called Southwest Airlines against Saxon. And this is a case that addresses the final proviso in Section 1 of the Federal Arbitration Act. And this is a provision that has figured in a couple of Supreme Court decisions. It's not one that figures that often in the arbitration cases, but it was the scope of the provision was at issue back in the day in a case called Circuit City, where the court construed it relatively narrowly. It was back up in the court just a few years ago in a case called New Prime against Oliveira, where the court construed it a little more broadly. And so this will be another opportunity for the court to consider this clause. The clause, and this is as most of these cases are, is a statutory interpretation case. So the particular text is important. Section 1 of the FAA, has some definitions and sets up the sort of the scope of some of the provisions. The main substantive section of the FAA is Section 2, which generally provides a pro-enforcement policy for arbitration agreements. But Section 1 and this final proviso does carve out certain employment contracts from the scope of the Federal Arbitration Act. And so its scope and coverage is therefore quite important. So the text is that nothing in the Act, quote, shall apply to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. The particular case here arises in the context of a supervisor for ramp agents for Southwest Airlines. If it's not immediately apparent to everyone what a ramp agent does, they basically help get the luggage from the plane onto the baggage cart in the main part of the airport. And this case involves somebody who's a supervisor of a variety of ramp agents. The line ramp agents, for the most part, are not directly at issue in this case because they're unionized and subject to collective bargaining agreements under separate federal statutes. But the issue here is really whether or not somebody who is involved in interstate commerce only in the sense of being on kind of the back end of a trip and getting people's luggage off the plane and onto the baggage cart, but individuals who don't really leave their jurisdiction, they work full-time at a particular airport. This particular case arises out of Midway Airport in Chicago. And so Ms. Saxon works at Midway. She doesn't get on the plane. She doesn't transport herself in interstate transportation or commerce herself, but she's obviously involved in something that you might describe as adjunct to the interstate transportation that the airlines provide. So this case ends up being one of these kind of wonderful cases about statutory construction. Every word is very important. And as I said, the court long ago, a decade or more ago in the Circuit City case made clear that this provision, and particularly its reference to any other class of workers engaged in foreign or interstate commerce, does not mean that sort of any worker engaged in commerce in the broadest modern Commerce Clause sense of the word is therefore exempted from the FAA with respect to their employment contracts. If it meant that, then a whole bunch of important Supreme Court cases, including the Epic case from a few terms ago, would have never been decided. So the scope of this provision is much narrower, but exactly how narrow becomes the critical issue in this case. And the critical phrase in this case is engaged in foreign or interstate commerce, which is a different and more specific term than Congress sometimes uses. Congress sometimes talks about laws affecting commerce or activities affecting commerce, but this is actually engaged in interstate commerce. And so the petitioner's argument is that that means you really have to be somebody who is directly involved in the crossing the state lines part of interstate transportation in interstate commerce, and simply being a baggage handler in Chicago and not leaving the Chicago airport doesn't qualify under the statute. I think it will be an interesting case to watch. I think one of the things that makes it interesting is that the last time that the Supreme Court construed this last proviso of Section 1, it actually ruled against the party seeking to enforce the arbitration agreement and said that the provision did extend to independent contractors involved in core interstate commerce. And that was the New Prime against Oliveira case. I used to think before the New Prime case that there were principally two kinds of Supreme Court arbitration cases. The cases where the Supreme Court enforced the arbitration agreement 9-0, and the cases where the Supreme Court enforced the arbitration agreement 5-4. New Prime against Oliveira was really the rare case where the parties seeking to vindicate their arbitration rights ended up on the short end of the case. I'm not predicting that will happen here. I'm just saying that because it involves this same proviso and an interesting statutory construction, I think it may be a case that will be very interesting to watch and could be less predictable than some other arbitration cases in previous terms. The next two cases I'll talk about are also argued in the March calendar. I'm actually have the privilege of arguing both of them. And in both cases, I'm on the side trying to vindicate the right to arbitrate. So feel free to take what I have to say about the cases with a grain of salt. I can't say I'm entirely indifferent to the issues or the outcomes in the case. The case that will be argued first of the two is a case called Morgan against Sundance. And this case involves an interesting and recurring issue about what happens if a party to an arbitration agreement waits some period of time and engages in some period of litigation before invoking their right to arbitrate. And in this case in particular, Sundance is a party to an arbitration agreement in an employment context. And the employee, even though she agreed to abide by an arbitration agreement, nonetheless sued Sundance in federal court. For a variety of reasons, Sundance did not immediately invoke its right to arbitrate under the contract. It was in the process of initially trying to see if the case could be essentially dismissed and consolidated with a previously filed case. There were then some efforts to settle the case. And then only after the settlement efforts proved unsuitable and the Supreme Court clarified that there was no possibility of a class-wide or collective arbitration. After all those things happened, then Sundance invoked its right to arbitrate. It was still before there had been any discovery in the case and before there had really been any material litigation on the merits of the case. The district court refused to enforce the arbitration agreement at that point, saying essentially that Sundance had waited too long. The Eighth Circuit reversed and said that Sundance could still enforce the arbitration agreement because Morgan, the plaintiff in the case in the litigation, had failed to show that she suffered any material prejudice from having to litigate on non-merits issues for a while before the arbitration agreement that she signed was invoked. The question as it comes to the Supreme Court is essentially whether or not there is a prejudice requirement in order to have a right to arbitrate waived or forfeited, depending on your perspective. The majority of circuits say that you can't lose your arbitration rights by waiting too long or litigating too long. unless the other party can show that they suffered material prejudice. That's the majority rule. The rule that Morgan seeks would be a rule where unless you invoke your right to arbitrate at the earliest feasible junction, you essentially lose your right to arbitrate, even if you can't show that the other side was prejudiced. There are a lot of interesting issues kind of floating around in this case, but what's the right way to think about it? There's a question about whether it should really be a matter of federal law and therefore provide an absolutely uniform answer, no matter where in the country you're litigating or arbitrating, or alternatively, whether you should think of it as really being a state law contract issue that would be resolved like some other state law contract defense. And then there's also a question of whether the primary provision of the Federal Arbitration Act to resolve this case should be Section 2 of the FAA or Section 3 of the FAA. The Section 2 is the basic enforce a provision unless it is unenforceable based on a state law defense that applies to all contracts. Section 3 is actually, in my view, more specific to the issues in this case because it basically addresses the circumstances in which a court should stay litigation in favor of an arbitration agreement. And it specifically provides that the court shall stay litigation in favor of an arbitration agreement unless the party seeking the stay is in default. So under that view, the case will ultimately turn on what is the meaning of in default for purposes of Section 3 of the FAA. I think it will be an interesting case to watch. I'm representing the respondent in the case. Anytime you represent the respondent in the case, you have to wonder why the court granted the cert petition in the first place. But I do feel like we have a variety of strong arguments in this case that you shouldn't lose a contractual right to arbitrate unless the other side can show material prejudice. The last case I'll talk about is Viking against Moriana. This is a very important case for anybody with operations in employees in the state of California. There is a California statute that is known and feared by the nomenclature of PAGA, P-A-G-A. It's the Private Attorney General's Act. And what this provision does is allow a single employee to sue for labor code violations, essentially on behalf of the entire workforce. As long as an employee can show that she has been subjected to at least one violation of the California Labor Code, then that employee can sue to recover penalties on behalf of all the employer's employees, even for labor code violations that she didn't suffer personally in any way, shape, or form. The question in the case is essentially when a party not only agrees, an employee not only agrees to arbitrate her disputes, but specifically agrees to a provision that waives her right to proceed in either arbitration or litigation with a class action or a collective action, or in this case, a PAGA action specifically, whether the waiver of that right to proceed collectively should be enforced and is valid under the Federal Arbitration Act, or whether that waiver of a right to proceed in some kind of collective fashion is itself a violation of state law or some other principle. In my own view, this case would be a much more difficult case if the Supreme Court hadn't decided a case called Concepcion a few years ago, and then also decided the Epic case a few terms ago, because in both of those contexts, the court said that the right to arbitrate, unless the parties provide otherwise, is really a right to arbitrate bilaterally. And so in that sense, if the parties can't enforce that right to arbitrate with each other bilaterally and waive the right to proceed in arbitration with a class action or a collective action or a PAGA action, that's inconsistent with the Federal Arbitration Act. So I see Glenn has showed up on the screen, which suggests that probably my time's up and I should turn it over to Michael.
No, actually, I showed up on the screen because I wanted to ask you a few questions before we turned over to Michael. So can you talk a little bit about this case that the California Supreme Court decided is Canian and what role that had in both increasing PAGA lawsuits and how that plays into the Viking River case?
I'd be delighted to. So, the Iskanian case is, to this case, what the Discover Bank rule was to Concepcion. And so these are state Supreme Court cases where the California Supreme Court is saying that in Concepcion, a class action waiver, in Iskanian, a so-called PAGA waiver, are unenforceable against state public policy. And that really sets the stage for these cases, because if, as my client was here, you're sued in California state court, as a matter of California state law, it's clear from the Iskanian decision that the PAGA waiver in the arbitration agreement is unenforceable. And so then the argument becomes, well, that's all well and good, but that state law rule is preempted by the Federal Arbitration Act. And the Supreme Court in the Concepcion case held 5-4 that the Discover Bank rule saying class action waivers are unenforceable was in fact preempted by the FAA. And our argument here is very much that the Iskanian rule is preempted by the FAA. It's an interesting artifact of this case that the Iskanian case is several years old, but even so, it's the real focus of our analysis in this case, because in our case, coming through state court, we really lost in the lower courts almost in summary fashion, with just very short opinions saying this is controlled by Iskanian. So this is one of these cases where, unlike the typical Supreme Court case where you talk a lot about the decision below, we end up talking a lot about the Iskanian decision from several years ago and not that much about the decision below.
Right. Yeah, no, that's interesting in that context. So in your Morgan case, there's quite an interesting group of amici on the Morgan side, a bunch of blue state attorneys general, public citizen, American Association for Justice, a bunch of law professors. What attracted them to this particular case?
That's an excellent question. I'm not really honestly sure. I think what may have caught at least the professors, who I think were the only group that was supporting the petition at the cert stage. I think some of these other groups you've mentioned have come along at the merit stage. But what I think intrigued them was the idea that this might be the case where you could try to sort of convince the court that when in the past it said that you have to treat arbitration at least as well as any other contract, that this is sort of the goose gander case to that this is the case where by applying the same rule to arbitration agreements as you do to other contractual agreements, that you have to apply this harsh no prejudice rule, because there are circumstances under state contract law where you can waive a contractual right without a showing of prejudice. I would say I think there are two very large problems with that argument. I mean, it seems attractive and clever at first blush, but one problem really at the threshold is I don't think it's right to think of the FAA and even the equal footing doctrine that's been articulated in a few arbitration cases as being a pure non-discrimination principle. I think it's much more like a most favored nations clause. And I think that really gets back to the heart of the FAA. I mean, the FAA was not a statute that was indifferent about arbitration and had any concern about reverse discrimination in favor of arbitration. That wasn't the problem Congress was dealing with in 1925. It was dealing with rampant judicial hostility to arbitration. And so I think it's just a kind of category mistake to say that the equal footing principle is a kind of non-discrimination principle that would be concerned about a court being too favorable to arbitration. But the second problem is there really isn't a state doctrine that makes it really easy to waive all sorts of contractual rights without showing prejudice, at least in the normal course. And it's almost a word game, because you can waive a right without showing prejudice to the other side if you pick up a piece of paper and say, I hereby expressly and consciously relinquish my right. But as the Supreme Court's pointed out in other contexts, a lot of times when lawyers and courts talk loosely about waiver, they're really talking about forfeiture, estoppel, latches. They're not talking about the rare case where somebody who's gone to the trouble of getting an arbitration agreement with the other side says, well, I've thought about it and now I'm going to absolutely waive that in writing consciously in advance. Instead, what they're really talking about are situations where the argument is really you should have invoked it earlier, or you engaged in some litigation conduct, which is really inconsistent with the idea of arbitrating. And the concepts that match onto those, and the foundation's brief does a very nice job of making this point. But the doctrines that map on to those situations where you waited too long or you did something somewhat inconsistent are doctrines like laches and estoppel, and they all require a showing of prejudice.
One last question before we move on to Michael. The Saxon case is obviously very interesting to us at WLF. We've filed in a number of cases where this issue of Section 1 and the transportation exception were raised, and several of which went up to the Supreme Court on cert petitions but weren't granted. What's special about this case, you think? How did it garner 4 votes where the other ones didn't?
So I think this may be a situation. First of all, it's good fact pattern. It is a situation where you have somebody they work for Southwest Airlines. So on the one hand, they clearly have some connection to the interstate transportation industry, but they also never leave Chicago. So if you're looking for kind of like the stylized case to figure out, is it enough to work for an airline? This case is a great sort of test case. I think the other thing that may have been helpful is, although this case came out of the Seventh Circuit, the cert petition did a nice job of suggesting the decision was actually inconsistent with a decision written by then Judge Barrett. And so, I obviously would just be speculating as to whether that argument appealed to now Justice Barrett or not. But it was certainly worth a try. And it seems like, all I can tell you is the court granted the case.
Thank you, Paul. If anybody has questions that's in the viewing audience, you can use the Q&A widget at the bottom, and we will ask those to the appropriate speaker. Michael, it's one time for you to give us your thoughts on the West Virginia versus EPA case and some other things in that realm.
Thank you. It's an honor to present here today, especially with such a distinguished co-panelist. I told my wife that getting to present alongside Paul Clement is like the legal equivalent of getting to go pull up to the majors for a game or two. But then again, maybe it's just being called up to the commentator's box. So West Virginia versus EPA. Supreme Court cases, in my view, fall into one of 2 camps most of the time. Either they're about technical, complicated questions that the lower courts haven't figured out how to consistently apply, or they're about big blockbuster issues of public concern. I think West Virginia is one of those rare cases that falls into both buckets. It has kind of an unlikely beginning, though. It arises from an obscure provision in Section 111 of the Clean Air Act, Section 111D. This allows the administrator, or actually requires the EPA administrator, to prescribe regulations which shall establish a procedure for states to submit pollution control plans for existing stationary sources of pollution for the EPA to approve. These state plans have to establish standards of performance for any existing source for any air pollutant covered by Section 111, which, since Massachusetts versus EPA, has included GHGs, greenhouse gases. So what is a standard of performance? The statute says that it's a standard for emissions of air pollutants, which reflects the degree of emissions limitation achievable through the application of the best system of emissions reduction that has been adequately demonstrated in the view of the EPA administrator. It's kind of a mouthful. A lot of things are in this case. For decades, though, this was interpreted, system was interpreted as being mechanical system. So stuff you can bolt on to a source or modify a source to make it more efficient or greener. That changed in 2015. And you might remember in the 2013 State of the Union address, President Obama said that Congress should pass a cap and trade law for greenhouse gas emissions. And then he threatened that if Congress won't act soon to protect future generations, I will. Well, as we know, Congress didn't act. And so President Obama asked EPA to step in. And EPA responded by creating the Clean Power Plan. And this uses the Section 111D authority in the Clean Air Act to create a centralized plan designed to make the American energy industry cleaner from the top down through cap and trade, what the rule calls generation shifting. And it did this by setting unachievable standards of performance for greenhouse gas emissions at disfavored sources, for instance, coal-fired power plants, and then requiring those sources to either shut down or buy emissions credits. So this was all very complicated because the statute on its face doesn't give this kind of authority. So the best way to understand it, I think actually came from EPA's own lawyer in oral argument for the DC Circuit, who explained it this way. In essence, the Clean Power Plan pulled out a map of America. It put colored pins in the map where the coal plants are, where gas plants are, where renewable plants are in the year around 2014. Then they made effectively another map with new pins for where they were projecting and wanted to see America's coal plants, gas plants, and the like, and where they thought the renewable plants should be 8 years into the future. Once it had done that, EPA reverse engineered its emissions limitations for different sources to drive the power industry from the first map to the second map over that time period. The rule was challenged in the DC Circuit very quickly. And when that court refused to give a stay, industry groups then went to the Supreme Court. And in one of Justice Scalia's final votes, the Supreme Court granted a stay of that rule, which was the first time the court had ever done that. EPA got the hint that it probably didn't have the authority it was claiming. And under the Trump administration, it repealed and replaced it in 2018 with a rule called the Affordable Clean Energy Rule, or ACE. And that rejected explicitly the statutory theory that the Clean Power Plan had for generation shifting. So this was, of course, also challenged, and that's the case that's currently before the court. The petitioners in this case argued that, in fact, Section 111D does authorize EPA to mandate generation shifting, and that the EPA's ACE rule was therefore premised on an incorrect understanding of the law. The DC Circuit agreed in a mammoth opinion that was issued just one day before President Biden's inauguration. And a group of states led by West Virginia and some industry groups, some companies, sought review with the Supreme Court. Most court watchers, me included, thought that this was likely going nowhere because the DC Circuit's opinion had stayed its mandate so as to allow EPA to come up with a new regulation. And following President Biden's inauguration, EPA said that it didn't have any interest in defending the ACE rule or in reinstating the Clean Power Plan, but would come up with something new on its own timetable. Nevertheless, the court surprised and granted reviews past October on one issue, which is the proper scope of EPA's authority under Section 111D. In my view, there are three key issues that are in play. The first is whether the court has jurisdiction. In order to get into court, litigants need to demonstrate standing, which requires some kind of concrete and particularized injury that could at least be somewhat redressed if they prevail in the lawsuit. The government and the environmental respondents in the case have argued that petitioners, the states and the coal and mining groups who are also seeking review, that they can't show any injury from the DC Circuit's ruling. I don't find that particularly convincing because in my view, if the court reverses, it's going to bring back the ACE rule. And if that happens, because a lot of these folks who are seeking review would stand to benefit from that, it seems to me pretty obvious that they get some kind of benefit. So, but maybe it's more complicated than that. We're still waiting to see the reply briefs from the states. The second issue is the scope of EPA's authority under the text of 111D. So the ACE rule says that if you read section 111A and 111D together, you see that the word for applies not only to any existing source, but also to the administrator's finding about the degree of emissions limitation achievable using EPA's preferred system, and that too has to be for any existing source. It's not the world's most elegant statutory text if you interlace the two that way, but it does make pretty good grammatical sense. But there are weaknesses in it, and the DC Circuit, in a very kind of grammar lesson way, rejected that, talking about things like implied indirect objects and the like. It's an interesting read if you have the time. Like I said, it's very long. And in the DC Circuit's view, system is kind of an open-ended thing, and the 111A inquiry is something kind of EPA can do in a vacuum. So it defines system using the Webster's dictionary as any complex unity formed of many often diverse parts subject to a common plan or serving a common purpose. It's pretty hard to think of anything more broad than that. My maybe somewhat unpopular opinion is that the textual arguments here are pretty strong, and that I think it's very likely that the court took this to reverse. And I wouldn't be at all surprised if they do so on the statutory text alone. The majority view, at least from the commenters I've been looking at, have said that that the court will find some ambiguity here. And if that's the case, that gets us to the third key issue. And this is the one that's captured the most attention and is most likely to make this an important case in a sort of broader way. And that's the major questions doctrine. This doctrine is about the scope of agency authority to interpret ambiguous statutory language. Ordinarily, if a statute's ambiguous, courts defer to reasonable agency interpretations of the statute. This is Chevron deference. The theory is that any ambiguity is an implicit delegation from Congress to the agency, and in particular to its experts, to fill in the gaps and effectuate the law's purpose. But the correctness of Chevron deference or its validity is a hotly contested issue and has been for a long time. Critics have said that it puts a thumb on the scale in the government's favor in a way that's unfair, and that it threatens separation of powers because it allows Congress to delegate legislative authority to the executive branch. Folks on the other side have said that deference is necessary because the world is complex and it's inevitable that judges are going to defer because they aren't experts in science or industrial policy or things like that. As for the separation of powers concerns, proponents of Chevron have often said that those realities require broad delegations of authority to agencies, and that as long as Congress gives an intelligible principle, at least some separation of powers formalities are respected. So the major questions doctrine, in my view, is a kind of judicial compromise that seeks to find a middle ground between these two camps. It's what Professor Pojanowski has called the neoclassical administrative law approach, which tries to reconcile the administrative state on the one hand with the rule of law and legislative supremacy on the other. So what does the doctrine actually say? The doctrine says, or reflects what the court has called the common sense view that Congress will speak clearly when authorizing agencies to make decisions of vast economic and political significance, and that judicial deference to agency interpretations of ambiguous statutory language in those contexts is not appropriate. In Justice Scalia's inimitable phrase, in these kinds of situations, the court is not willing to stand on the dock and wave goodbye as an agency embarks on a multi-year voyage of discovery. But ironically, what constitutes a major question is itself something of a big question. How clear does the clear statement have to be? How vast is vast enough? What constitutes sufficiently economic or political significance? I think a lot of folks are hoping that this case will provide some needed clarity on this. The scope of the doctrine, especially if it's broad, will have a lot of consequences for how administrative law is done. Especially with Congress deadlocked, this administration has been putting out regulations that reinterpret authority, statutory authority, to do all kinds of novel things. So EPA, for instance, recently used its authority to regulate mobile source emissions from cars to effectively require a significant portion of new cars to be electric. Agencies like the SEC have been pushing climate change related regulations through their financial regulation authority. And of course, we just recently saw the court effectively strike down the OSHA vaccine mandate because OSHA had tried to regulate public health through a statute that was focused on ensuring workplace safety. It's too soon, of course, to say with any confidence how the court's going to handle any of this. It could be a nothing burger. It could be an apocal case, who knows? But it's going to be very interesting to hear in a few weeks how argument goes and what the justices are thinking about these issues. The other case that I'll remark on briefly is the abortion cases that came up, not because of the abortion issue, but because of justiciability. Those cases, you might remember, are about pretty interesting law that was crafted by a guy named Jonathan Mitchell that allows citizens to sue abortion providers and doesn't allow any government authority to do anything in administering or enforcing the law. The abortion providers went to court to try to get pre-enforcement review, but it was kind of unclear who are you going to sue. And so they ended up suing a number of different people, including a state court judge and a state court clerk. And they asked for an injunction saying that those folks couldn't hear or even docket the cases. This is important because for over 100 years, under a case called Ex parte Young, the Supreme Court has held that you can get pre-enforcement review, but only if you're suing the officers who are going to enforce it. And at oral argument, it seemed like the court was thinking, or at least a number of members of the court were thinking, that it might be important to revisit this and expand it. Ultimately, however, the court stuck with its traditional doctrine. I think it is an important signal, though, for future cases, because it shows that I think a lot of the court, both on the more conservative side and on the liberal side, really care about pre-enforcement review. And I think that's a blessing and a curse maybe for the business community, since some regulations you like, others you don't. If you had to weigh things, maybe that it tends to reward activist litigators, but I think it's an important doctrine, and one that's clear isn't going anywhere in the near future, and is probably going to be expanded if you get cases that sort of test the limits.
Michael, on the administrative law side, what did you learn as a lawyer who's very interested in and practices in administrative law from the NFIB decision?
Yeah, so I think the NFIB decision suggests a broad consensus at the court that major questions is important and is going to do a lot of legal work. The key point there was there's no question that this is a massive undertaking that OSHA was trying to do to basically mandate vaccinations for everyone who works at a place that has more than 100 employees. And I think that was like 80% of the US workforce. And the rule of decision there was like, hey, OSHA, you get to regulate workplace safety. And maybe these things have some connection to workplace safety. But you went way broader than that in the way you made this rule, and that's a problem. It's interesting that the court didn't go as far as Justice Gorsuch wanted to in his concurrence, which kind of hammered this kind of point more aggressively, and really emphasized that this was not the kind of thing that the agency was tasked with doing or had any expertise or right to do, in his view. And he also, I think there was a footnote in that where he referenced something that Ron Klain had tweeted about how this was a workaround. And I think that suggests that, if you're in an administration, you should be very careful about what you're saying, you're trying to do with the rules you make. And that's actually kind of a continuation from some of the Trump cases, the census case and some of these other cases where the court really took maybe a harder look than it usually has at what the agency officials at issue said or thought or commented on, requiring them to really be doing what they're supposed to be doing and not something else.
Was there anything that you wanted to remark on the 3 arbitration cases? Anything that you see there that might be interesting to note that Paul may not have?
One interesting thing about the Iskanian decision, and full disclosure, I did an amicus brief in the Viking River Cruises case on behalf of a California industry group that its whole reason for existence is to oppose PAGA or PAGA. There was some PAGA lawyer who had a Rolls Royce. I think this made it into Paul's brief. A Rolls Royce with a Mr. PAGA license plate. It's pretty awesome. So that was published by my client. They figured that out. But the Iskanian decision is interesting because of the way it tries to justify why it viewed these private attorney general type actions as not falling within the FAA. And it said basically that the real party in interest is the state. It's not the person who's bringing the suit. The person is just a bounty hunter. I think that introduces a false dichotomy. Private suits have public interests that are in play. That's why you have punitive damages, for example, in tort cases. And then often public cases have specific individual interests that are in play too. I mean, the obvious thing is if you're the victim of like a fraud or something like that, and the government brings an enforcement action, right? Your interests are also in play. So I think the court failed to, the California Supreme Court failed to really distinguish or to think carefully about that. And in fact, there's some interesting case law from like the 1890s where the Supreme Court went on kind of at length about this point. So I think it will be interesting to see, or one thing I'm kind of curious about is how the kind of conceptualization that Iskanian had about what the cause of action is going to be viewed. It's interesting for this case. It's also interesting because I think citizen suits, like with this abortion case, are kind of a topic that the court's been curious about for a long time, but has never really gotten into. In some of the environmental cases that mostly from the last decade, the court has suggested that maybe there's a separation of powers issue, but that stuff really hasn't been litigated. So the more attention that gets put on those, on how citizen suits work and what the kind of contours might be is just going to be interesting to see in the future.
So with PAGA suits, are they like QI-TAM suits under the False Claims Act, where the government gets a portion of the reward if the QI-TAM relator is successful, or is the PAGA suits strictly private litigation?
Yeah, it's I should have mentioned that earlier. It is kind of like QI-TAM, and that's certainly how Iskanian, the California Supreme Court decision, characterized it. What's interesting is it's really kind of a reverse QI-TAM, though. The state gets 75% of the ultimate reward, but it has no control over it. Once the case, it has to go through a little bit of an approval process first, where the state can take over if it wants to. But if it doesn't take over, the cause of action goes to the private party, and they can do whatever they want with it. There's nothing the state can do to stop it or change it. And so it stands to get a bounty, but it doesn't actually have any control over how the interests are vindicated. And the distinction here is, I think, QI-TAM is, you don't have to be injured to be a QI-TAM plaintiff. And here, because the way that works is you get an assignment of the government's claim. Here, in order to sue under PAGA, you have to be aggrieved. You have to be injured by some kind of violation of the California Labor Code to bring suit.
Okay. Quick question on the West Virginia case. Among the many interesting amicus briefs that were in support of EPA was one by a group of senators led by Senator Whitehouse, who doesn't think much of amicus briefs himself most of the time, but he took it upon himself to file one here. So that brief argues that the claim is non-justiciable because it's basically just a political question. Is there any chance that that argument's going to appeal to any of the justices?
I only skimmed his brief, so I'm going off my fairly limited memory here. There's so many briefs in this case, but I think justiciability is going to be an issue that will probably get some attention, but not political question. I think that it's not a political question. It's this is a quintessentially technocratic Clean Air Act case at bottom about the scope of EPA's authority.
Okay. Paul, I wanted you to say some words about Justice Breyer, since you've argued numerous cases before him and you've been in the same circle for quite a while. What does he leave behind at the court, and what will you remember most of him?
I'm glad you asked, Glenn. He was somebody who I obviously got to argue in front of a number of times. He was on the court when I first joined the SG's office. So he's been on the court for virtually every one of my arguments, if not every one of them. And he's a unique justice, both on the bench and in his opinions. And I'd say a word about both. On the bench, what I'll remember the most is, he asked questions like nobody else. They were longer. They were often multi-part questions. But the nice thing about them is they genuinely showed his thinking. He was never hiding the ball. He would tell you, here's what I think is the, kind of the hardest argument you got to deal with. What do you think? And they were open-ended questions, often in the sense that he would add them with, what do you think, or what do you say to this? But it really did give you an opportunity to watch his, formidable intellect kind of at work, and he would give you a sense of kind of what he was thinking and what he thought was the hard arguments against you. And as an advocate, can you really ask for anything more than that? I mean, I really think, that's what you want. You want to know what the justices are thinking, and you want to have an opportunity to respond. And he always sort of gave his own thinking and gave you an opportunity to respond. So it was a delight to have on the bench. Back in the SG's office, when I had, the opportunity to do a fair number of sort of arguments as an amicus where you only had 10 minutes and there was a 2.5-minute question, that could sometimes be taxing. But otherwise, it was our pleasure to get the chance to present argument to him. In his decision-making, I think he really is the court's kind of foremost pragmatist right now. And I think that will be missed. He was somebody who you felt like you could often reach in a case where, if you just looked at it from the sort of standard kind of, judicial conservative philosophy, or the standard more sort of, less restrained judicial philosophy, you might think, okay, this is going to break down into two camps. And he was a justice who sometimes had a foot in both camps, and you could sometimes persuade to come your way, in part because he really was looking at it almost in a slightly different dimension than some of the other justices. It wasn't just all about the doctrine. It was also about the pragmatism. It was about, would this work? Could that be something that Congress was plausibly thinking at the time that it passed the statute? And there were situations where he could provide, the critical vote for a proposition that might surprise some people. I was working on a brief earlier today in the religious liberty area, and just as an example in that context, he cast the decisive vote to not sort of remove the 10 Commandments monument from the Texas Capitol grounds. And although, he often was more skeptical of, sort of religious exercise or expression than some other justices, I think he really understood in that case, in a way some of the other justices didn't, the kind of powerful image there would be of like literally removing the 10 Commandments that had been there for 40 or 50 years and sort of taking a crane and hauling him out. I mean, that's the kind of argument that sort of, could reach him. And I think that will be missed. I think that, there are different ways in which the court divides. And I think that, sometimes it's more along judicial philosophy or the party of the president who appointed you. But at times there was almost like a divide on the court between the pragmatists and the theoreticians. And I think losing the sort of chief pragmatist on the court, I think will maybe have more of an impact than people realize right now.
Michael, any thoughts on Justice Breyer?
I chuckled when Senator Romney told the president that he hoped that he would nominate someone in the mold of Justice Breyer, because that mold's only been used once, as far as I can tell. I can't imagine what it's like, Paul, being getting those 8-part questions and the tomato children or those kind of things that he would ask about. But I definitely agree on the pragmatism point, and I think there is a sense in which Senator Romney's question makes a lot of sense to me, which is having, not only is Justice Breyer a pragmatist, but he's someone who's really tried to articulate that theory as part of our constitutional design and the job of a justice or a judge. He's written a number of books that touch on these kind of things. I think in a lot of ways he's put forward one of the most full-throated defenses or responses to kind of the formalist views of Justice Scalia or Justice Thomas. And it's going to be interesting with, whoever takes his place, if it's going to, if that person is going to have that same willingness or interest in it wrangling with and kind of pushing back on that on that view or that jurisprudence, because I think that's been one of the sort of markers of the court has been this debate between the originalists and the non-originalists, and it's a super interesting one, and I'm just interested in how it's going to play out in the future.
I think one of the benefits of the way that the court conducted its business during the pandemic and still is now, that people actually got to hear the kind of questions that justices like Justice Breyer asked. And one of the things that always struck me was that he was always very interested in asking advocates, help me figure out how we're going to decide this case without it getting completely out of control. Like what limiting principles, how can we cabin our decisions so it's more around these facts rather than some sort of broad sweeping edict. And I think that goes to the pragmatism that Paul was talking about. Any cert petitions that you're involved in right now, following that people should keep an eye out for? Again, probably cases obviously they'll be heard next term, but they're still issuing grants for a couple of weeks, I imagine.
Yeah, I'll just mention one petition that I filed a couple of weeks ago that sort of pending with the court. It involves a statute out in Seattle where Seattle had the idea that people who are in the hotel business or who are kind of co-located with hotels ought to be providing the local workers of Seattle with better health benefits than they provide elsewhere across the nation. You can see why that would be very attractive to a bright blue municipality, because you could get the benefit of providing cutting edge healthcare to your citizens, and you could do it largely on the basis of corporations that are based elsewhere. There would seem to be a fairly obvious obstacle to doing what Seattle did, which is the ERISA preemption clause, which makes it pretty clear that employers get to provide a uniform package of health benefits to their workers across the country. But the Ninth Circuit, kind of relying on a case from almost a decade ago that generated a 9-justice dissent from en banc, a cert petition, a call for the views of the Solicitor General, and then sort of fizzled out because, believe it or not, the government said, I think the Affordable Care Act will make this all go away. So the Affordable Care Act did not make it all go away. Seattle is doing basically what San Francisco did a decade earlier. But on the strength of this earlier Ninth Circuit case, the Ninth Circuit has allowed the Seattle ordinance to go into effect. So we filed a petition in that case. We have a fair amount of amicus support. And, I do think that's one to watch, because sometimes ERISA cases can be very inaccessible. I mean, they're important. There's the stakes are sufficiently high that even the least accessible ERISA case is important. But this is one where I think it's fairly accessible as far as ERISA cases go. You can easily understand the temptation of the municipalities to pass these kind of laws. If the Ninth Circuit decision stands and the court doesn't take the case, you can imagine that these kind of statutes are going to proliferate. In fact, there was an amicus brief filed in the Ninth Circuit in support of Seattle that was, filed by, almost exactly who you'd expect it to be filed by. It's a group of municipalities that included, San Francisco and Los Angeles, and I think Austin, Texas. So I do think that's a case that's worth watching. You never know with cert petitions, but it seems like one that has a real chance to get the court's attention.
Michael, any you're aware of?
I've got my hopes up about Dakota Access versus Standing Rock Sioux Tribe. So this is a case about NEPA and the scope of what the environmental analysis has to be to resolve criticisms, and also about whether if you have a procedural error under NEPA, whether that can warrant a remand with vacatur. NEPA is an interesting issue, and it's going to continue to be a huge, effectively a huge tax on all forms of development that have any kind of real government nexus or federal government nexus. I think my hopes have gotten up for this a little bit because in addition to West Virginia versus EPA, the court a few weeks ago granted Sackett versus EPA, which is going to be a really interesting case next term about the scope of the Clean Water Act. The Clean Water Act gives federal jurisdiction over to EPA over navigable waters, but doesn't really define that. And for decades, and of course, with a hard to understand Justice Kennedy opinion in the mix, it's divided the Supreme Court, lower courts, and has resulted in a consistent back and forth between Republican and Democratic administrations that's left everything very muddled. And so this case, I think it has some justiciability issues as well, but I think they took it, so I don't think those are going to predominate. And I think that's going to be a great case next term to watch.
That's the second time that the Sacketts have been up to the Supreme Court.
Yeah, that's right. That's right.
Friends at Pacific Legal Foundation, they've become very accustomed to getting up there at the Supreme Court. Well, not seeing that there's any questions from our audience right now, I want to bring this to a close. Thank you, Paul, and thank you, Michael, for taking your time today to provide us with some insights on some of the cases that are coming up before us and one that the court's decided. And I think it's going to be a very interesting term. Hopefully all of the noise that will be around the confirmation process of Justice Breyer's replacement won't drown out what I think is going to be some very interesting court decisions to come. Thank you again very much. Take care.
Thank you.